today's meeting, we have PRC Chairman Alan Bozeman, Commissioner Tom Kolaluka, Commissioner Debbie Southerington, Rebecca Kupczynski, Shannon Carney, Albert Bukahine, George Vaughn, Nora Poor, Amy Markwitt-Runwald, Jim Budzik, and Jonathan Schick. Chairman Bozeman, we are ready to begin the meeting if you would like to call the order.
Yes. Meeting called to order. So first things first is the approval of the minutes from our February 12th, 2020 meeting.
I'm sorry, Chairman Bozeman, this is Shannon. Do you need me to call the roll first, please?
Oh, I'm sorry. I thought that's what you were just doing. Okay, yes, please
No.
call the roll.
All right. Chairman Bozeman?
Here.
Commissioner Kolaluka?
Here.
Commissioner Southerington?
Here.
All commissioners are present. We have a quorum.
Okay. All right. Motion to approve the minutes from our February 12th, 2020 meeting.
Second.
All in favor?
Aye.
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 Okay. Is there any public comment?
There is no public comment.
Okay. So on to new business. We have one appeal here. Is it Sharice Walker?
Yes. That is correct.
Okay. Is Sharice on the? I guess who goes? The appellant would go first, right?
Right.
Okay. Is the appellant here?
Jim Budzik is here representing the appellant.
Yes.
Okay. The floor is yours.
Thank you. Good afternoon, Commissioners. In this particular appeal, and certainly, yes, I do represent the appellant. The appellant stands by the report and recommendation of the hearing officer in this particular case. Mr. Zeiser, in this case, determined that Ms. Walker was guilty of minor misconduct and ultimately recommended a 3-day unpaid suspension. From a the county is the one, the appointing authority is the one who filed objections in this case. As I understand their objections, it was twofold. One is on procedures, one is on the merits. With regard to the procedures, the record is very clear that under 13.04, Rule 1304 of your own rules, it states that if a party does not provide a witness and document list prior to the hearing, then they are not permitted to introduce the testimony or documents at the actual record hearing. In this particular case, the appointing authority did not present its materials in a timely manner. The hearing officer the parties did not, at several conferences on this, did not agree to a certain time frame. So what's called the default provisions of 1304 would apply. That would mean 2 weeks prior to the hearing, both sides would have to submit documents. Appellant did submit her witness and documents list both 2 weeks prior to the first scheduled meeting, and then again prior to within the 2 weeks prior to the second meeting, rescheduled meeting. The appellant, the appointing authority, did not file documents within that 2 week time frame. The hearing officer exercised his discretion under the rule and said that he was not going to consider those documents or testimony. Interestingly enough, he did say even if he would consider those documents, it would not change his opinion in the very least, because the evidence in this case was very clear that Ms. Walker was treated in a disparate manner. There were multiple employees who engaged in a group text that was inappropriate. Ms. Walker stated that as her PDC. She again stated that at the record hearing. The other employees received discipline ranging from a oral reprimand to a 5-day suspension. And the hearing officer carefully went through, all those cases, and stated certainly on the number of those other individuals, they were actually found guilty of harassing another employee and engaging in misconduct. Ms. Gary was also involved, as the hearing officer found as being the most egregious, also had falsifying her timesheet, neglecting of duties, as well as conduct unbecoming. That was the most egregious case. She ended up with a 5-day suspension. It was only the appellant in this case who received a termination. Basically, the hearing, the appointing authority council stated that she could not be trusted. Ms. Walker had.
I'm sorry to interrupt. There is 1 minute remaining.
Thank you.
Prior to this, she had no disciplinary action in her record. The hearing officer again went through all this and stated that the other employees received discipline, again ranging, as I said, from a reprimand to a shorter term suspension, and certainly one, if not two, of the other cases, Ms. Gary and Ms. Cinnamon Scott certainly was worse than Ms. Walker's, and received a 3 and a 5-day suspension. Hearing officer again recommended a 3-day suspension based upon this entire record of her testimony and everything that he did here at the record hearing. We ask that you affirm the hearing officer's decision in toto, and that
The time is up. The 5-minute limit is up. I apologize.
Thank you. Thank you.
No problem. Thank you. Quick question, Jim. You said that you believe that she was treated in a disparate manner. What do you think the basis of that, the reason she was treated differently were? Is there any qualities of her?
The hearing officer basically went through that, which we agreed with, which we presented. You had a series of FSAs. Ms. Walker was an entry-level scheduler, and again, she did not have any type of supervisory authority or anything along those lines. The hearing officer found that from a functional standpoint, the employees were the same. They were investigated as one unit. The appointing authority was one unit. Everything was done as one unit. That, as he noted, that is in all material respects, the employees were similarly situated. They were investigated the same. The appointing authorities the same, but they were not treated the same. And that's what he concluded.
No,
that was the basis of the appellant's case.
No, I understand that. I'm saying, why do you think she was treated differently? Is there a distinguishing characteristic of hers? Yeah. Like, do you think it's because of, like, are you saying this is like a gender disparity or a race disparity, or is there something about?
No, we did not. We did not raise. We did not raise that. We did not raise race as as an issue, or gender. The other FSAs were part of a union. I don't think that I don't know if they were just trying to give the union people a break. That issue, I believe, was brought up, but as I indicated, as the hearing officer indicated, all the employees were disciplined only under the rules and the policy manual of the county. There was nothing unique about the other union employees. I don't know. Again, the burden's on the employer to prove everything was consistent and that they had sufficient proof and that the punishment fit the crime. And as I argued on her behalf, clearly the the alleged wrongdoing did not fit the wrongdoing, and this was especially espoused by the hearing officer, because again, he said for all material purposes, all these employees are materially the same, and therefore you have to treat them in the same manner. We did not argue race or gender discrimination. No.
Okay. And what I'm also asking is, are there any of those distinguishing factors? Is there something that distinguishes her from the group? Is there anything that distinguishes her from the group other than
she was a non-union employee? I don't believe so. Obviously, non-union employees at a PDC hearing are not entitled to representation, whereas union employees are entitled to representation at a PDC hearing.
Yep. Okay. Does anybody else have any questions?
No
questions.
questions.
Mr. Budzik, Tom Kolaluka, was there any agreement with the appointing authority regarding admission of the documents beyond the prescribed time limit?
No. I agreed to a continuance of the first hearing because I was waiting for certain public records requests that we had asked for.
Okay.
But there was no agreement, and therefore, I just assumed that the timeline, that we would use the 2-week time limit. In fact, it was the day after, and Ms. Renwald made a email complaint about some of my exhibits. I said, by the way, you never even filed your exhibits.
Okay. Deborah, anything?
No questions.
Okay. All right. Amy, you're up next.
All right, I'm gonna mute my phone.
Thank you. This is Amy Marquette Renwald on behalf of Appellee County Executive.
Yeah.
Let me first address Mr. Kolaluka's question, which was there any agreement to admit exchange exhibit and witness list late? And in fact, there was an agreement. When the original hearing date had been scheduled, the county approached appellant's counsel and wanted to discuss requesting that the hearing date be postponed, which it ultimately was. And appellant's counsel's response to that request was, well, I don't object to some extra time to get your witness and exhibit list together, but I'm not sure about objecting to an extension of the hearing date. So right from the onset, appellant's counsel was indicating, even if our hearing is still in 2 weeks, you can file your exhibit and witness list a little bit late if you need more time. So he gave that initial consent to additional time for the county in less than the 2 weeks prior to the hearing to exchange its list. The history of this was laid out in the county's objections to the R&R as far as
Counsel, did you, this is Tom Kolaluka, I apologize for interrupting you. Did you present this discussion that you had with Mr. Budzik to the hearing officer?
Not at that time. What we ended up presenting was the joint request to move all dates because both parties had reasons why we wanted a continuance. And so both parties requested that the hearing date be moved, and it was. And what happened in this case was a simple oversight by the county, where the county had prepared all of its things to exchange, but because the parties had requested the date to be moved, traditionally when a date is moved, the parties wait until the next deadline to exchange their witness and exhibit list. But in this case, appellant, for some reason, had filed her witness and exhibit list a week earlier than the deadline. So when the day that appellant's attorney filed his appearance in this case, he filed and exchanged his witness and exhibit list, which was a whole week early. And so the county had prepared to submit its witness and exhibit list by the deadline, but by the deadline, the parties had already agreed to request a continuance. And so the county held back and didn't exchange its list. But then at the point when discussions ensued and we were talking about moving the dates and other evidentiary issues, it was a simple insight on my part that I thought I had filed because I had already prepared them. And so when the new date came, I mistakenly thought that I had already exchanged those lists. And so at the point where the new 2-week deadline came, an appellant at the end of the day filed a revised list, it was only then that it was brought to my attention that I had never actually filed the county's list. Now, the county wants to take issue with the argument that appellant makes, which is there can't be prejudice because there was no harm. That was the county's argument. And the appellant argues that there's kind of a de facto harm because how could the appellant not be prejudiced if she filed her list and the county didn't file its list until the day after? But that makes no sense because appellant herself filed her list a week before the deadline. And so she invites harm, if that's her argument. She invited her own harm by filing her list a week before the county had any obligation to exchange its list. So that argument makes no sense. And ultimately, the hearing officer does have discretion, but there's no
Amy,
basis.
I'm sorry, you have 1 minute left, Amy. Thank you.
Since I interrupted her, could you give her extra time?
Yeah, I was going to say,
Yeah.
we'll give her a couple more minutes.
Okay,
Add
thank
another minute to that.
Absolutely.
Thank you.
So, Amy, just to put a bow on that, so what you're saying is the reason that your list didn't get filed on time was because there was an agreement or you thought there was an agreement to continue dates, so you didn't think that you would need to file it by that deadline. And then by the time kind of everything got wrapped up, you realized I never filed my exhibit list. Is that true? Is that what you're saying?
That is what I'm saying. So originally, we had an agreement. The appellant consented to some additional time for the county to file its exhibits, and then the hearing officer granted our joint request to move the date. So all dates were moved forward. And so at the point where we finally, it was 2 months later, where we finally got a date for the hearing, it was at that point that I mistakenly assumed I had originally filed my list because I had prepared them, but I just never exchanged them because the dates were moving. And so I had a memory of preparing them, and I thought, okay, I already did that. I don't have any revisions. And so I didn't file anything. But then when appellant filed hers, and I raised a totally different objection to hers, that's when the appellant raised the fact that I hadn't actually filed the county's list. And so the very next day, I filed them. So instead of 14 days prior to the hearing, it was 13 days prior to the hearing. And so the county's point is, yes, there was a 14-day deadline. Yes, the hearing officer has discretion. But in this case, it was a simple oversight, and there was absolutely no prejudice. In fact, the appellant asserted that she had all of those documents already from her own public record request. So there was no surprise as to what the documents were at the point where she received them 1 day late.
Okay.
So unless you have any other questions procedurally, I want to move on to the substance.
No, please move on to the substance. And
Okay.
you have 2 minutes.
Okay. Thank you. So the appellant and Commissioner Bozeman rightfully asked, what is the disparate treatment, if any? And here, there was no disparate treatment because they were not similarly situated. And the hearing officer really failed in this regard to consider the evidence, whereas the group of employees who were involved in this group chat, all of them were aides, family service aides, except for the appellant. The aides have an entirely different set of responsibilities, and what distinguishes the appellant here is that she had an immense amount of discretion. Appellant will characterize herself as an entry-level position, but Exhibit A from the county is her classification spec, And it states that 40% of her responsibilities is to assign and monitor services provided by those aides. And so she doesn't just schedule. She's not just someone looking at a calendar. She is assigning aides to service clients and making sure that clients receive those services. And so the amount of discretion she holds is something that the hearing officer really didn't give any attention to. And that was the very problem in this case, is that the appellant was able to favor her friends, the aides, over other aides in giving them the clients they wanted, in the geographic locations they wanted, and covering up entirely unauthorized refusals to show up to service a client. And that might not seem terrible, except for the fact that the evidence shows that the clients didn't get service. And the services that these aides are providing to these clients is very important. It's going into their home, checking on their health and their medical care, changing wounds, helping them use the bathroom, simple bathing, feeding them, and then also communicating to their family members if there's any change in their medical status. And so the fact that appellant was abusing her discretion to change the schedules of these aides, cover up unauthorized call-offs, it resulted in the clients not being served. And that is
It has been 2 minutes.
Large.
Let the record show.
I'm
Go ahead
sorry?
and finish your thought. That was 2 minutes. Go ahead and finish your thought, and then we'll move on.
So that was a very important and huge distinguishing factor between appellant and the aides. And the other point I wanted to make was that the insubordination piece is big. So here, the hearing officer found as a finding of fact, number 3, that the appellant told one of the aides to delete the group chat. The other aides had not read the email. So at the point where Michelle Gary texted another aide and said, delete it, I don't know why Sharice told me to, she didn't know why Sharice was telling her to. Sharice was the one who read the email from her supervisor to say, preserve this, and immediately told the aides to delete it. And so there are huge trust issues, huge discretionary issues that the appellant abused. She was not similarly situated. She had a very different level of responsibility and job duties than these other employees who were disciplined differently. So I'm sorry I'm out of time. If you have any questions, I'm happy to answer them.
Sure. Tom, do you have any other questions?
No, I'm good.
Deborah, do you have any other questions?
Questions?
No questions? So I'm thinking here, and I know that the appellant believes that none of the information that would have been submitted would have changed things, but it seems to be that this technicality did deprive the county of the right to present all the evidence it wanted to present. And so I'm inclined to make a motion that this matter be remanded to allow the county to present whatever evidence wasn't allowed, and then we can make a decision once we feel that there's been a full and fair opportunity to actually evaluate this on the merits. So motion I have here now is a motion to remand this matter back to the hearing officer to allow the county to present the evidence that wasn't allowed to be presented in the initial hearing.
Second.
All in favor?
This is Amy from the county. If I may, I know procedurally a party normally wouldn't speak at this point of the hearing, but the hearing officer did permit all evidence to be heard at the hearing. So he, at the onset of the hearing, he heard the appellant's objection to the county's evidence. He heard oral argument by the parties, and then proceeded to hear all evidence. So the parties,
Okay.
The county's documents and witnesses did give testimony.
Okay. So everything has been heard is what you're saying?
As far as the county's concerned, yes.
Okay. And I'm
Mr. Budzik, do you agree with that?
With her assessment, no, because the hearing officer made it very clear, saying, had he considered everything, which again, Amy already noted that he did hear everything, his opinion wouldn't change. He was treated disparately as compared to the other group of employees.
Yeah.
Okay.
Rebecca.
Yes, sir.
Is there any way for us to kick our decision to the next meeting?
Yes, we can, you can, just postpone taking any action on it at this point, and we can put it on an agenda for another meeting, since we do not have the ability for you to deliberate on this phone call, if I'm correct. Is that correct, Jonathan?
Yeah,
We
that's
don't have-
correct. That's correct.
We don't have the ability to go into a private session at this point. The only way that we're able to do the executive session later in the meeting is that everybody else who's present in the meeting is going to be cut off the call at that point in time. And, but the deliberations, we don't have the technical capacity to do that.
Yeah, I think that we need that. Does anybody disagree with me?
No.
I want to make sure that the both council understand why this is happening this way.
Why?
For Amy, on behalf of the county, I do understand. If it's a question of needing more time to read the briefs or consider, that's one question. But if I would not object to you deliberating, deliberating at the point where you break for executive session. I'll be on the call, this entire time. So if it's just the procedural issue.
Amy, it's Tom. The procedural issue is we don't have the technological capacity here at this point in time to go into deliberation. We don't need more time to review the briefs, at least I do not, and your arguments, because you both were very concise and precise. We just don't have the technological ability to confer, and that's the issue. And we don't want to cause a technical problem here with any procedural appeal that may happen after this because we didn't deliberate properly.
Amy, if I can clarify what's happening from a technological perspective, and people who work for me will laugh when I say that, but essentially what's happening is there are two calls going on at the same time right now. IT is managing this process. When we go into executive session, the commissioners and I and our legal counsel are going to go and continue on with that phone call. The people that are on the other call are all going to be, that call is going to be discontinued at that point. Now, usually you have some questions about what's going to happen after the executive session, and I can tell you that there are two resolutions, one about furloughs and one about layoffs, that we're going to be talking about after that resumes, after executive session resumes, and I can send you those so you can see those if they're approved by the commissioners. But that's the only business that we have on the agenda after the executive session will take place. So that's how we can manage the bifurcation of the call. We're simply going to cut one off at that point.
Well, because of that issue, would you consider moving the executive session to the very end so that I can continue attending the meeting for the other matters?
The only thing that's going on beyond that executive session is their consideration and any action that they might take on those two proposed resolutions. That's all that's left to be discussed at that point.
Is there a reason why? Okay.
Are you saying
I imagine
why when we go into deliberations we can't deliberate? I mean, when we go into executive session at that time we can't deliberate over this matter. Is that what you're asking, Amy?
Well, that was my original question: was could you do your deliberations in this appeal on the same call as you're having your executive session? just so we don't have to kick it to the next meeting. But then my other question is, because I'm supposed to be attending these meetings, how do I continue
Right.
to attend if I can't hear the last two items?
So let me ask Jonathan while we're in process here. I'm sorry, Jonathan, we didn't anticipate this. If Amy is cut off on that other call, can we then send her the invite for the executive session so she can call in again and join when we get back on the record after the executive session?
Yeah, that would be your prerogative.
Okay.
We certainly could do that. Or we could
What
open the
we
other
would-
line back up as well, either way.
Oh, okay. So she could call back into the same line that she called into originally.
Yeah, the host of that line would just have to make it available once again. And we could just send them a text when that time is ready or something like that.
So Amy, what you would need to do is, if you have the ability, after we cut you off for the executive session, if you would send Shannon an email. Can you see your email right now, Shannon? Or send me an email with your cell phone number in it, and we can text you when it's time to call back in and join the meeting.
Okay, that sounds good.
Does that work? Okay.
Yep.
And then they can deliberate in executive session.
Okay, so you will deliberate on this appeal today in executive session?
If that's what the commissioners want to do.
Yeah, we can do that.
Okay.
Okay, so I'll email Shannon. Thank you.
Thank you.
And I guess Jim needs to be able to get back in too then, right?
Yes. So Jim, same thing. If you could shoot Shannon an email that has your text, a phone we can send you a text on, and then you can both call back in.
Okay,
All right? Good. Thank you.
okay.
So you
Thank
can put
you.
that item on hold.
Okay, so we'll put that appeal on hold. And so we're moving on now to PRC Resolution 2020-001. Shannon, would you please read the summary of the resolution to the record?
Yes, PRC Resolution Number 2020-001, a resolution adopting changes to the Cuyahoga County Personnel Review Commission's Employee Handbook and an Electronic Communications and Equipment Policy effective April 23rd, 2020.
So just to give you some background on this resolution, if you remember last August, the county came forward with a number of changes that they were making to their handbook. You guys approved those at that time, and they went to council and were approved and adopted by the county. This is us just doing the same changes to our handbook so that we're consistent with the county. And we incorporated everything that they made in the way of changes in that handbook. And I believe I sent you a summary of those changes a couple weeks ago.
Yep. Okay. Motion to approve PRC Resolution 2020-001. Do I have a second?
Second.
All in favor?
Aye.
All right. It's carried. Now we move on to the establishment of the eligibility list as of the date posted to the PRC website. George, would you like to speak on this?
Yes. Commissioners, you were sent a summary, an extensive summary of the eligibility lists that have been posted to our site since the first of the year, and I would be happy to answer any questions you have about that summary.
No
I have no questions.
Okay. Yeah, I don't have any questions either. Okay. Motion to approve the establishment of the eligibility list as of the date posted to the PRC website.
Second.
All in favor?
Aye.
All right. That is carried. Now we move on to the request to use pre-existing eligibility lists. You all have the letter from George Vaughn. You guys all have the letter from George?
Yes.
Yes.
Does anybody have any questions?
No questions.
No question.
Then I'm going to make a motion to approve the request from CJFS to use pre-existing list for program officer from the HSS Director's Office. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Okay. And then we have revisions to the county classification plan. You all have received these materials for the revisions. Albert, would you care to speak to this?
Good afternoon, Commissioners. Before you are modifications to the county's non-bargaining classification plans that you received summary of earlier in the week. One was posted earlier in the year on February 27th, 2020, and the last one was posted on April 16th, 2020. Be happy to answer any questions you have.
No questions.
No questions.
I don't have any questions either. Okay, so motion to approve the revisions to the county classification plan.
Second.
All in favor?
Aye.
Aye. All right.
Thank you.
So, thank you. So now we're going to motion to close this meeting to go into executive, or not close, but to pause it to go into executive session.
Second.
All in favor?
Aye.
Okay.
Can I just be, as a matter of procedure, Shannon, do you have the phone numbers for both Amy and Jim Budzik?
Yes, I do. They both just sent them to me.
Okay, so we're prepared to go forward. Good, thank you.
Rebecca, this is Albert. I'm assuming George, you don't need George and I to call back in?
That's correct.
Okay, thank you.
It'll be lonely
Thank
without you.
Thank you. So Jonathan, you'll let us know when the other call is discontinued so we.
Yes, and I'm gonna pause the stream as well.
Okay.